extreme welcome in this special session. There are 4 speakers, and I'm honored to chair Kees Blankman, endowed professor elder law, VU University Amsterdam. We are really the 6 of us, but I will tell you that a few moments later. This session is special on advanced care planning and advanced statements. And we noted that there is a difference between disciplines, that when you have to think about the future and possible situations of mental incapacity, then lawyers, they say there are instruments, make an advanced directed non-treatment or continuing powers of attorney. And when you speak to doctors, they say, well, there is a kind of a process where you have to talk all the way with the patient. And there's a difference. And this afternoon, with your help, we'd like to bridge this gap. There is a gap. And we have a perfect setup of speakers, 2 lawyers and 2 from the medical point of view discipline. And the next person that we are going to introduce is Paul. Look at Paul. This is Paul. Yeah. You can see that he is 74 years. He used to be a teacher, singing in a choir. I don't know if bass or whatever. Maybe he had a beard, I don't know. I think a beard is beautiful. Doesn't matter. Married to Karen. 2 daughters. They're all very relevant for the case that we are going to discuss, because all the 4 speakers are going to do something with this case. He's diagnosed with early age Alzheimer disease, and he has made an advance directive. That's the start. Now, the first speaker I'd like to introduce is Adrian Ward. We know a lot in the history from each other. Come closer, Adrian, please. Yeah. Former solicitor in Scotland, national and international specialist in law for people with cognitive impairments, actively involved in, I think, still the Essex Autonomy Project, if I'm well, and one of the leaders of this project of European Law Institute, I think, aimed at improving legislation application of advanced decision. We're very honored for you to speak. The floor is yours, please. Yeah.
Thank you, Kees. Here's a quotation, just to set the scene. I wrote it myself. It seems like doctors give too much deference to lawyers, and lawyers give too much deference to doctors. And I wrote that in 1990. The point I was making, in context, was that they should not defer to each other, they should talk to each other. Here, from more recent practice, is an example of what I mean. 2 sisters came to see me with their father. An old-age psychiatrist had advised them to get themselves appointed as his guardians. I spoke to him first. Yes, he was happy that his daughters should be appointed. He told me why. He told me about his assets, which included a second home. I asked him for the address. He laughed. I knew you would catch me out sooner or later. That's the sort of thing I can't easily remember anymore. You'll have to ask the girls. I phoned the psychiatrist. I told her how well he had done in a relaxed conversation, his daughters beside him, before, as he thought, we started the real business of what we were going to be doing. I explained that I told him how well he'd done before he thought we got down to business with his daughters. I explained that, at least in our law, a person can appoint an attorney if they know who to choose and what they want the attorney to do, even though they might be unable to do all of that themselves. We agreed that if I saw him again and he did as well, I could take his instructions and certify a power of attorney, quoting her, the psychiatrist, as my consultee. We needed both sides of that collaboration between professionals to achieve the most appropriate outcome for him. Things have shifted since I wrote that book in 1990. Then we lived in a binary world of complete capacity or complete incapacity. with incapacity presumed from medical diagnosis. We moved from that medical model to the social model, largely relied upon by the UN Disability Convention. The problem is not the disability, but the barriers created by society. Now we have moved yet again to a human rights model, with a starting point of whether the individual's rights are being respected, and if not, how that can be achieved. This, however, has been a cumulative process. Diagnosis is still often of vital importance, but in a broader, multidisciplinary context. When I was supporting one elderly client to give what I believed to be competent instructions, and I prepared documents, I could never coax him into actually signing them. It took a psychiatrist to tell me his diagnosis, and that a recognized consequence of that diagnosis, and many decades of not being treated for it, was an inability actually to commit to anything. With that evidence, I obtained a court order to sign a particularly important document on his behalf. Likewise, the lessons of the social phase still apply. If society is presenting barriers, they must be removed. Two human rights principles are particularly relevant. The first is the right to support under Article 12.3 of the UN Disability Convention. The second is the right to autonomy and self-determination under relevant Council of Europe recommendations. Principle 2.7 urges states to prioritize those principles. Issued a decade later, Principle 1 of Recommendation 2009-11 requires them to do so. Just let you read those. We get the same from Principle 14 of Recommendation 2014-2. So this is becoming directive where it was once advising. And in 2014, also in 2014, this is what the Council of Europe said to medical practitioners. A formal written document appears to be the safest and most reliable way of making known one's wishes expressed in advance. Accordingly, written advance directives are the means that most directly reflect patients' wishes. When they exist, they should take precedence over any other non-medical opinion expressed during the decision-making process. The current Law Institute project that Kees mentioned uses the Council of Europe definition of advance directives. Excuse me. But we've added in the requirements. Sorry, that one, first of all, that's the starting point, and we've added in Principle 14, which says what they can do. Note that advance directives may apply to health, welfare, or other personal matters, economic and financial matters, and to the choice of a guardian, should one be appointed. So it's a very broad range, potential range, not just medical, not just even personal matters, almost anything that somebody could do or decide for themselves. However, to the first part of that definition, having regard to Article 12.4 of the UN Disability Convention, which refers to rights, will, and preferences, we needed to add preferences to the mix. So we have instructions, preferences, and wishes. Go back to Principle 14. Principle 14, in effect, allows people to do and decide for the future anything they can do or decide now. In Europe, there's been major development of powers of attorney and regimes for advance directives limited to medical matters, or even more limited to mental health matters, but none for advanced directives as defined by the Council of Europe. That's astonishing. Why? It's astonishing because they're at the top of the hierarchy for compliance with human rights principles of measures that relate to the exercise of legal capacity, as Article 12.4 calls them, particularly those rights to support autonomy and self-determination. In that hierarchy, voluntary measures under which people make their own arrangements excuse me, are preferable to non-voluntary measures imposed by a court or authority, or even by automatic operation of law. However, among voluntary measures, even under powers of attorney, someone else is appointed to act and decide. Under advanced choices, grantors act and decide for themselves. But a major issue is that they grant the advanced choice, it goes into a tunnel, then comes out of that tunnel some time ahead without knowing what may have happened above ground in the meantime, unless it has been updated. Current thinking of our project is that when it comes out of that tunnel and becomes operable, there should be a hierarchy of criteria for disapplication in particular circumstances. At the top of the hierarchy is the robustness of the advanced choice document, both procedurally as regards formalities and its content. There is no reason why that approach should not apply now, in advance of the laws that we might propose. Now, you've already heard about Paul. There he is again. You'll hear the story of Paul developing. I'm not going to develop it any further. As it develops, you can bear in mind the following questions arising from my presentation. When granting his advance directive, did he consult medical professionals about the likely course of his illness and resulting support requirements? Did he consult appropriate professionals about likely future options and scenarios for care? Did he consult a lawyer about exactly how he would word his document and what those words meant? Did those various professionals collaborate with each other? And did he record all this in the document? Just hold those questions and think about them when you hear the rest of this combined presentation. Perhaps no one had the opportunity to check out the scenarios that he envisaged and what he meant by the words care home and institution, when I can tell you, he said in his advance directive, that's a place he didn't want to go to. Did he mean all possible such sessions? Or were there some aspects only of life in a care home or an institution which were what he really objected to? Did he object to having to live apart from his wife? There is a hint of that in a little twist at the end of the story when you hear it. I'm going to end with another real story. Family were perplexed at their relative's insistence that he wanted to go home when that seemed entirely impractical. I advised taking him home for a visit to see how he reacted to the reality. "Why did you bring me here?" was his question. He was visualizing the family home that he left in his youth many decades before. From the viewpoint of the cross-European project that I am leading, collaboration between disciplines is essential to the advanced care planning. Thank you.
Thank you, Adrian. There is room for one question, if Adrian, if you want to make... Yeah, no, perfect within time. Is there a question? And this is also a moment to say that there are also digital communication possible. You can write your question. I can have it over there. But first,
of course, I have a question because I'm very interested in one aspect of your work. And given the fact we have a UK lawyer and a Dutch lawyer here, does the Now, are there any relevant differences between you operating in the system of common law and you in the system of civil law or civic law? And does it in any way impact the way your findings can be interpreted in the Netherlands and vice versa?
Well,
I'm going to answer that question slightly differently. I don't live and work in a civil law in a common law system. UK has a border across the middle. The Romans built a wall there. North of that wall, we operate in a civil law system. South of it, in a common law system. And I could give you quite a long lecture on the relevance of the differences between the two, but we have to bridge that gap. And it creates issues like, we hear a lot of talk about the difference between supported and supported decision-making and so on, and substitute decision-making. And when we were doing our law reform process in the 1990s, England had huge arguments about that, and we in Scotland didn't. And I analysed that as a consequence of that difference. Because, of course, the UN Convention doesn't mention either, and the draftsman intended to stay out of that argument. And I think part of the reason they wanted to stay out is it applies to the common law world. You folk, most of you in the civil law world, why do you get worried about it? It doesn't apply to you. But I'll let Kees answer for himself, because I have to give a double answer.
For discussion later on, I first have to introduce Eefje Sizoo. Thank you for being here, and thank you, Adrian, for your excellent presentation. Eefje, you are a senior researcher at the VU Academic Medical Center Amsterdam, right?
Yes.
We work together in some projects, and also a specialist in geriatric medicine with practical experience, I think. You worked, yes. And you did a lot of research on mental capacity, we know that, advanced care planning, and end-of-life decision, right? Yeah, yes. Floor is yours.
Yes. First, a disclaimer, I'm an elderly care physician, which is a specialty in the Netherlands, quite unique. And we provide care for people with dementia living at home and in the long-term care facilities. So, and the focus of my talk is decision-making about care and treatments with people with dementia. And I will start with a brief overview of the concept of capacity, and then I will continue to the healthcare practice of decision-making with people with dementia. And this is quite complex, actually. Well, as we all know, people with dementia have the cognitive decline, and it probably will, eventually will affect decision-making ability. And when healthcare professionals during the disease trajectory of people with dementia, numerous healthcare decisions need to be made. And when healthcare professionals propose a treatment or care plan, they should explore whether the person has the ability to make that specific decision. And usually this is luckily an implicit part of the process and the interaction between the professional and the person it concerns. It's quite stressing if someone is actually judging you. And usually neither of them are aware of it unless there are signs of lacking capacity. And what is that capacity? It contains four aspects. Someone is called capacity to take a decision if he's able to understand the information relevant to the decision, to retain that information, to use or weigh that information as a part of the process of making the decision. And this also concerns to be able to apply the decision onto his own situation. And it also means to see some of the consequences for others of your decision. And the last but not least, someone needs to be able to communicate the decision, but that does not have to be in words, can also be in sign language or by any other mean. And luckily, over the last 30 years, and I think particularly over the last 10 years, there have been a paradigm shift in the way how we think about this in practice. Well, the old paradigm is put here in black and white. Someone either has capacity to take a specific decision or lacks capacity. And the question we needed to ask each other was, can this person make a decision for himself, or should the decision be taken over? And the new paradigm is the concept of decision-making ability, which is defined as the extent to which someone is able to make a decision. And the question we need to ask ourselves then is, what support does this person need? And as you all know, in people with dementia, it's not a black and white concept. People do not develop dementia overnight, but it's actually 50 shades of gray, and support can be given in all this part of the process. So now we look at Paul. We're now 2 years later after the diagnosis, and Paul and Karen live in the moment. They do not receive professional care. They don't want that because they manage it together. Paul had the cognitive decline in the meanwhile, and he lacks initiative to take care of himself. Sometimes he gets lost when he's not familiar in a space, and some small accidents happen. For example, he left the oven on once, and there was smoke everywhere, so Karen is quite stressed in leaving him alone. And all of a sudden, Karen had a severe stroke. She needs to stay in the hospital, and in a few days it has become clear that she needs to stay there at least for a few weeks and go to a rehabilitation ward. And in the hospital she's very worried about Paul, and she expresses, but he arranged everything. He wrote something down. Well, the daughters come in and stay with their father the first few days, and they think that Paul cannot take care of himself. Because they worried, and they propose admittance to a nursing home, probably temporarily, but maybe longer. But Paul, he does not agree. He thinks he can take care of himself. His daughters do not need to worry and do not need to stay with him. He can manage on his own. And the advanced directive was found. It contains a do not resuscitate order and a refusal of treatment in case a condition warrants admission to an institution. And with the institution, he specified both hospital and nursing home. So if you look at the decision at hand we have here, it's temporary admission to a nursing home that was proposed. And we can see that Paul can communicate a goal and a choice. He's more or less able to understand the choice, but he lacks sufficient insight to apply it to his own situation. And he can search for options, but he's unable to weigh them. We also see some reflection on effects for himself and others. He's particularly worried about his wife in the hospital, and he does not want her to worry about him. So if you look at the old paradigm, you can conclude that he lacks sufficient capacity for the decision at hand. He cannot do it alone. So within the old paradigm, the decisions should be taken over. The advanced directive here is not specific for this decision. So, and then according to Dutch law, another person should take the decision. And according to the Dutch law, this will be a legal representative. And if not someone is appointed, then it will be the wife or one of the daughters. In other jurisdictions, a physician can, for example, take the decision. So the decision should be taken over. But within a new paradigm, we can ask ourselves how we can support Paul in the decision-making process and try to respect his choice as much as possible. Well, Paul lacks decision-making capacity, but we have all seen that he can still express preferences. And he also expressed relevant preferences in his advanced directive. So in a large project we're doing about the role of an advanced directive in people with advanced dementia, we drew this triangle. And we see that we should consider all the 3 angles of this triangle. And I'm going to do this in the next slides. And the first perspective is the perspective of the person himself, of course. He's central. Well, persons with dementia, people with dementia can express their values and choices. Sometimes it requires effort, but well, we heard yesterday in the beautiful opening session what they can do and how much they can tell us about what they want. Research also had shown that important factors are that people are involved indeed, and they refer to maintaining autonomy. And I think this is a beautiful quote, and I think I actually heard it yesterday too, which is say, I'm still here, I need to be respected. On the other hand, people with dementia also often realize that they have to adapt to a situation of diminishing independence, and they search for a balance of hanging on versus letting go of specific decisions. So people can actually prefer to take a part of the decision, but leave another part of the decisions to someone else. You see throughout the disease trajectory that there occurs a gradual shift from supported to substitute decision-making. And one of my colleagues, Kees Hertog, with other colleagues proposed this acronym for healthcare professionals. What you can do and what you can have in mind if you want to support someone with taking these decisions. And it contains 5 steps, not necessarily in this order, but the A stands for assess the strengths and deficits. It can be this cognitive deficits, but also what are the strengths of this person, for example, a supportive carer, or anything else, or an environmental factor can be supportive as well. You should simplify the tasks. You can cut off, for example, the decision into little pieces and do not present one large decision with a lot of complex aspects. Third, and I think this is the most important one, you have to know the person. What is important for this person right now, but also what are his long-held values and beliefs. The M stands for maximize the ability to understand, think about an empty, quiet room, take the time, pick the right time of the day, and invite that supportive carer, for example. And you can also use visual aids. And the E stands for enable participation in decision making. You can tailor, when you assessed the 4 former steps, you can tailor the complexity of the decision to the decision at hand. Then the second part of the triangle, the advanced directive. Well, advanced directives are defined as written instructions executed by decisionally capable adults that pertain to future medical treatment preferences. And when they were found, this was quite a black and white concept because they only take effect when someone lacks capacity. So that's the black and white old paradigm. However, the underlying motive is obviously good. It's respecting autonomy, but actually this is a precedent autonomy. So I myself can decide for myself over 10 years, and that sounds perfect, but there might occur a potential conflict between prior values and current interests. And this is a discussion actually already covered a few sessions ago. And one of my colleagues called this the misleading simplicity of advanced directives. 20 years after advanced directives were actually implemented, he concluded that advanced directives often contain vague or ambiguous instructions, and they're not the actual decision it has to go about. That's not in the advanced directive, and it often provides a little guidance to routine medical decisions. And 2 quotes are really important here because people can change their minds. They adapt to the situation of living with dementia, and particularly when their minds change, they may appreciate other things. And second, there is also a gap between the hypothetical scenarios that are sketched and the decision-making process in practice. And we see that here in Paul too, because he's talking about a non-treatment, but treatment is not the problem. The problem is there's no carer available anymore, and that's a different problem. Well, the third angle is the legal representative. And this is good news. People with dementia are reliable, able, and are really consistent in pointing out who should be their representative. People with beginning dementia and with moderate dementia can do that too. And usually they prefer a close informal caregiver as a legal representative for several reasons. This person can be trusted and also understands the perspective and the values of the person it concerns. However, he or she can also be biased by their own preference. So as a healthcare professional, you need to be aware of that. And they also have their own concerns, and you see that here the daughter, she also has a family, and she has to take care of her father. And so there's also an interconnection between the best interests of the person it concerns and the representative. And you also have to be aware of that and make that explicit. Well, how do legal representatives decide if they have to decide on behalf of a person with dementia? Relies on the known wishes of the person, also consults others, so other family members, for example, or other professionals involved, and needs to strike a balance between the respect the wishes of the person, but also the best interest, because sometimes if someone does not have any intakes and he sets his house on fire, then it's not something you want either. And we see that the final decision is more emotional than rational. And professional guardians as legal representatives also occur, but that's only in a minority of the people. And that's often the case when there is no informal caregiver around or there are conflicts within the family, then it's easy to have another person. But they usually rely on medical and legal authorities. So what about Paul? Well, let's come back to the decision at hand. Well, we see that Paul can communicate a goal and choice, and he prefers to stay at home if possible. And he wishes not to be admitted to a nursing home. He's more or less able to understand the choice, but he lacks sufficient insight to apply the choice to his own situation. He has some reflection on the effects for himself and others, and he can search for options, but he's unable to weigh them. The advance directive was not specific for the decision at hand, but contained relevant information. Namely, Paul does not want to go to an institution, and he is willing to take a risk because he had a do-not treatment in case my condition warrants admission to a nursing home. So he wants to take some risk. While the daughters have another perspective, which is not in line with Paul. They think it's more safe if Paul can stay at home, stay in a nursing home. And now you have to weigh this. And is it proportional to admit Paul right now, under the current circumstances, to a nursing home against his will? Well, we think there's a less intrusive possibility, and this is what is proposed. So the elderly care physician consulted talks to Paul and expresses the concerns the daughters have. And Paul is actually sensitive to the arguments, and he consents to 2 times a day home care, meal service, and a case manager. And then there's an evaluation after a week. And furthermore, the daughters who are worried about the gas and the oven accident, so they shut off the gas and remove the oven. And they're going to evaluate in a week. And Jenny is going to continue later on. So this was my presentation.
Thank you, Eefje. Thank you. Yeah. Okay. I think we should go on to the next presentation and leave the questions for later on, if you agree. If you don't agree, we do the same. Yeah. The next speaker. Rieneke. We work close together. You're assistant professor at the Faculty of Law, VU Amsterdam. And you will be defending your thesis, your doctoral thesis, on continuing powers of attorney next year, January. Perfect.
Yes.
And you're project manager, I can tell it, of a €2 million research project aimed at improving the legal landscape for vulnerable adults in the next decade. Quite an ambitious job, yeah?
Yes.
The floor is yours.
Thank you so much, Kees. Yes, so I will talk about a study I conducted as part of my PhD research on the Dutch levenstestament. And I hope to end with the argument that advanced statements cannot go without advanced care planning. So when we talk about advanced decision-making instruments, 2 instruments are generally distinguished. And we have the continuing power of attorney on the one hand, which is defined as a mandate given by a capable adult with the purpose that it shall remain in force or enter into force in the event of his incapacity. So I have a fault on the slide. And advanced directives, instructions given or wishes made by a capable adult concerning issues that may arise in the event of his or her incapacity. And both instruments can, in the Netherlands, be included in one and the same instrument, which is known as a levenstestament. So instead of an advanced directive, I've twisted the case of Paul a bit, and Paul has now made a levenstestament, including both a continuing power of attorney. He has appointed his wife, Karen, as primary attorney, and his daughters, Angela and Janine, as substitute attorneys. And his levenstestament also includes a medical treatment advance directive, as we saw before. And Paul says that he has arranged everything, and the question is that the case? And I'll come back to that. So when we look at the literature talking about the potential of advanced decision-making instruments, we see the following. So Gergel has indicated that they can be seen as a way forward in protecting the adult's right to autonomy by making the adult's voice an influential component of future decision-making. So it's a way for the adult to express his wishes and preferences in advance to be taken in account in the future. I myself have highlighted the potential of advanced decision-making instruments as providing for a flexible transition between supported and substitute decision-making. So on the one hand, when it's still possible, Paul can be supported by Karen to still take his own decisions. And you have to imagine that also involves like suggesting that a certain decision must be taken or executing Paul's wishes with regard to a certain decision. So Karen can first provide that support. And then when Paul is no longer able to take a certain decision, Karen can act and decide for Paul based on his previously expressed wishes and preferences. And as we've seen in Eefje's presentation, both forms of support can also go hand in hand, because capacity is not a black and white concept, but a dynamic concept. An important question is whether this potential is realized in practice, and that is a question I explored in an interview study I conducted as part of my PhD research. I conducted 23 interviews with adults who had recently made a levenstestament and 6 interviews with nominated attorneys. And I conducted 16 interviews with active attorneys, and that were people who had recently started or who had been active for quite some time, so there was a range. And unfortunately, I don't have time today to delve in all the results of this study, so that's why I put the article on the slide. You can look it up and read it. It's published open access in the International Journal of Law and Psychiatry. But what I hope to do today is to shed some light on 2 observations I drew from this study, which I think might be more relevant than just the Dutch context. There was a question earlier on about whether it's more broadly relevant. I put the disclaimer here that it's a qualitative study and I looked at the Dutch context, but I think these concerns might apply more broadly and should be the focus of further research looking at the potential of advanced decision-making instruments. So advanced decision-making instruments such as the levenstestament become applicable in a certain context. They become active in a certain context. They capture the adult's wishes, preferences, and instructions at a given time, but life itself is dynamic. So while the instrument is static, life itself is dynamic, and wishes and preferences that were once important to Paul might change over time. It can also be difficult for Paul, while making the advanced directive, the levenstestament, to oversee future needs. So that has to be taken into account. And that also creates certain risks with regard to whether that potential of advanced decision-making instruments is realized in practice. And today I would like to highlight 2 risks. So when we think about the context in which advanced decision-making instruments such as the levenstestament become active, and realizing that it's a static instrument compared to the dynamic nature of life, that first of all makes it important that perhaps the instrument can be changed when wishes and preferences change or when future needs become more clearer. But what, at least in the Netherlands, is the case, and perhaps also in other countries, is that while the instrument itself is already static, that static nature can even be enhanced, for example, by the formalities of creation of such an instrument or the costs of making such an instrument. And that was the case in the Netherlands, where it is a particularly costly exercise to make a levenstestament. It's on average 400 euros to make one. And that resulted in a situation in which notaries, where a levenstestament is often made by the adult, said to the adult, don't include too detailed wishes, preferences and instructions in the levenstestament. They also advised the adult to include a broad conferral of authority for the attorney in the levenstestament to cover all future scenarios. And that creates the risk that there is little information as to the adult's voice in the levenstestament itself. So although there is a lot the attorney can do, he has a broad conferral of authority, he knows little about what the adult wants him to do. Let me have, if I see this correctly. Yes. And that's why I subsequently looked at the idea of advanced care planning, which is defined as follows on the slide. If seen as an ongoing process rather than a one-off episode of form completion, advanced care planning can provide a supportive structure to help family carers navigate their decision-making journey alongside their loved one living with dementia. So what I did is, I concluded that there is a risk that little information as to the adult's wishes and preferences, as to the adult's voice, is included in the levenstestament. But is there then, are there subsequent discussions about wishes and preferences? And that is the second risk I would like to discuss today, because I already said when I discussed the case of Paul, that Paul had said, I have arranged everything. So what I found in the interview study is that people, some of the people who had made a levenstestament thought, now I'm done with it. I've made it. I can put it in the drawer. I can lock the cupboard. And when it becomes relevant, my representatives, my wife, my daughters, they will find it. The nominated attorneys, and as you could see on this, I told you there were only 6 people who I could interview. That was also because not every person who had been nominated knew they had been nominated as attorney. But the persons I spoke to often relied on the information as to wishes and preferences being included in the levenstestament, whether that was actually not the case. So you can see that on the slide, Karen, Angela and Janine, they assume Paul's wishes, preferences and instructions are recorded in the levenstestament, and we can consult these when they become relevant. So there is a risk that the levenstestament, or the advanced decision-making instrument, becomes a one-off episode and then is not followed up by conversations between the adult and the attorneys. And I also inquired in my study why that is the case, and that is because adults and attorneys find it difficult to engage in timely and ongoing conversations about the adult's changing wishes and preferences. And in some cases are also not aware of the importance of doing so. And what I also saw from the interviews with active attorneys is that such conversations become even harder when there is a decline of cognitive abilities. And what was striking for me is people telling me that it became more and more difficult to have such conversations. I wish I had these conversations before, because now it's increasingly difficult to have these conversations about wishes and preferences. So I think an important question is, how can we promote conversations about the future we perhaps rather not talk about? That's a question I leave unanswered in my dissertation. There's only so much you can explore, but it's a question I hope you will all take home and think about. I think in the Netherlands there's an important role for notaries to at least initiate this process. So people go to a notary's office to make a levenstestament. I think it's important that notaries make sure that the adult not leaves it there, not stops when the levenstestament has been made, but also follows up with his attorney. And as I said, I hope you will continue to think about other ideas in which we can promote such conversations, because in the end it's something that concerns us all, I think. My take-home message for today: in designing advanced decision-making instruments, we should also strive to ensure they reach their full potential in practice. So it might look good on paper, but we need to make sure they also work in practice, and that the full potential in terms of the adult's voice being heard is realized. Thank you.
Definitely, yeah, thank you. Okay. Thank you very much. There is room for one question, if you stay. Is there a question somewhere? You can have the microphone then. Is there someone who wants to ask something or have a comment on potential? Yes, the phone is going to you. Just a moment. Please use the mic. Yeah.
Hi, thank you for this interesting presentation. I was wondering, is it always necessary that an attorney is involved, or could you also write down your wishes and somewhere? And I also noticed in the presentation of Eefje, it said that things have to be written down by a capable person. And I think, how do you know that this person was capable when writing it down?
Yeah, so I think in the Netherlands, at least, for medical wishes and preferences, it's not necessary. It's not necessary that they're drafted at a notary's office, because physicians use them in a process of advanced care planning. But when you talk about financial decisions, for example, then in practice, banks do not accept a levenstestament that has not been made at a notary's office. So they need that guarantee that a person had the capacity to make the document. So it really depends on the kind of wishes and preferences and instructions you want to include in the document. Yeah.
Okay, thank you very much. Yes. We go. Last speaker, Jenny, we are glad you joined our team. I will introduce you. Jenny van der Steen, epidemiologist, right? If I pronounce it well, epidemiologist.
Epidemiologist.
Yeah, thank you.
Yes,
Yeah, okay.
sorry.
Senior researcher at Radboud University Medical Center Nijmegen, and also Leiden University Medical Center. Yes, both, right? And your field of expertise is palliative care in case of dementia, correct? Yeah. Floor is yours.
That's right. Thank you, Kees. And thank you for inviting me to this symposium. So I'm going to talk about advanced care planning, a moving conceptualization. That's something perhaps you also felt in the talks of the other speakers. And we go beyond the dichotomy of whether you have capacity or not towards inclusiveness. So if people have diminished capacity, we want to include them in advanced care planning. Now, advanced care planning is part of palliative care, because palliative care is a very proactive form of care and a multidisciplinary. That's 10 years ago, we did with the European Association for Palliative Care a task force on what is it exactly. And then you can see that advanced care planning is one of 8 care-related domains. And it also relates to person-centered care, communication, and shared decision-making. Now, for this new task force we did with the European Association with Palliative Care on advanced care planning in dementia, we started with a generic definition of advanced care planning, which was for people with decisional capacity. And we revised this framework to apply it to dementia. And from the revisions, we abstracted 3 themes. 3 things are different and need particular attention in the case of dementia, which is increasing difficulty communicating with a person, decline of mental capacity, and changing roles and involvement of family. So these themes all relate to changes. And then we started outlining, okay, who are the stakeholders here? What happens over time? So we started with this very simple graph. You have a physician, a family, and a patient. And when the patient can be less involved, then the family gets more involved. And then with our task force of 14 experts, we had 41 versions before we arrived at the version we presented to 107 panelists from 33 countries, and still we had 4 more versions to arrive at this graph. So it shows a bit the gray zones that Eefje was talking about. It's more colorful, but you can see that there must be gray zones of when a person still has capacity for a certain decision. Now, we started with this simple graph, and then later on we added that you can start conversations outside healthcare. So the person with dementia and the family, they can speak about what they want in the future without the involvement of the healthcare professional. So that could be promoted by visualizing this with this graph. It shows that the role, the engagement of the person with dementia declines, but it's not a straight line. It's fluctuating decline. And when the person's engagement diminishes, then the role of the family gets stronger, but also the role of the healthcare professional. So this is what we arrived at. It's going to be published in Alzheimer Dementia soon. The 3 themes we have at the graph. But actually, the old idea was that the person with dementia at some point cannot be involved at all. So then the line suddenly drops and the family takes over. And this is also the model with legal capacity for a certain decision. At some point, you don't have legal capacity anymore, so the person is not involved. Now, where is Paul and his wife and his daughters? Now, continue with the case. What happens is a few weeks later, Karen is admitted to a geriatric rehab ward, and Paul and his daughters are coping well with the new situation, which is, however, precarious. The physician offers to discuss what to do in the case of a sudden decline in Paul's health. His advance directive said, refusal of any treatment when my condition warrants admission to a hospital or a nursing home. The physician asked, what do you mean by this? But Paul doesn't understand the phrasing, and he doesn't recognize the advance directive as his. However, he declares he's afraid to be admitted to an institution, and he wants to stay home if possible. The physician explains that some treatments are only possible in the hospital. And Paul says, well, I have no objection to the hospital as long as it makes me feel better. The physician is puzzled by this answer and continues by probing how he feels about another institution, a nursing home. The physician explains that at some point he might need more help than the home care and daughters can provide. Living in an apartment in a long-term care facility where Karen is rehabilitating might be an option. And Paul still does not want to live in a nursing home, but he consents to have a look. So Paul doesn't have enough understanding for legal capacity for the decision whether or not to go to a nursing home. But he has capacity to express his current wishes upon communication that is tailored to his capacity. And also the advance directive is still a starting point for the conversation. And the physician asked to explain this, and that is also showing how Paul is doing with his capacity. So where is Paul on this line? We feel he may be here. He can contribute, he has a role in advanced care planning conversation, despite that he has not the full legal capacity he needs to take this decision. Now, the concept of advanced care planning is moving. It's moving upstream, what happened with palliative care as well. It's not only about end of life. We want to integrate it in the care, so you need to move it upstream and not limit to end of life. The same is happening with advanced care planning. The context now is that it is part of a broader umbrella of care planning. So you can have care planning while you're still healthy, And you can have care planning with serious illness, and you could have care planning at the end of life. And in all those cases, you can have in-the-moment decisions, and you can have in-advance decisions. So this is a care planning continuing. It starts before serious illness, and then there are the two decisions, and they're related, in-the-moment decisions and advanced decisions. In-the-moment decision could be based in part on advanced decisions. And the end of life is not, it need not necessarily be all about the end of life. So that's what happens with integration upstream in the care trajectory. Now with the EIPC, we did more with the task force. We looked at boundaries of what is advanced care planning with dementia, what is not advanced care planning, and these are the consensus statements that it can include discussion of current care, but it should be about the future. But it's not about the future, it's not advanced care planning. And also talking about the end of life is preferred, but it's not necessary. Unless you're very close to the end of life, then it's the near future. Of course, then you need to talk about the end of life. And this is the abbreviated version of the new definition we made. This is the definition for people with capacity only, the starting point. That was published in Lancet Oncology. It's also work of EIPC. So this is for people with capacity. It actually is not a real definition. It says what's the goal of advanced care planning. It enables individuals. This is how we revised it. And this is what we arrived at. It's a process of communication, that's what it is. And it is with family, if available, the healthcare team, and preferably with ongoing conversations and preferably also with documentation. Not necessarily so that you would need to draw up an advanced directive, but it is preferred to at least summarize the discussions. And a very important difference is that it is continued when the person with dementia cannot make decisions anymore. So during our work, we made a mission statement. So we went from that generic definition for people with full decision capacity exclusively to make a more inclusive definition for people with dementia with diminished capacity and a tailored approach for specific groups. And I know there's people with dementia who think we don't want to be special, we don't need a special definition, but our feeling was with the generic definition, you are excluded at some point. So it needs to be continued after the point of legal capacity drops. Then we explored more boundaries about participation. And of course, the current communication and responses of people with dementia are the basis for advanced care planning conversation. So you can start outside the healthcare setting without the professional. It can be conducted in the form of eliciting values without referring to the dementia. If the person with dementia is unsure whether they have dementia or doesn't want to talk about it, you can still elicit values and find out what people find important. It's also advanced care planning if you start with a family or a proxy who is really knowledgeable about the wishes of the person with dementia, and knowledgeable through previous communications or responses or experiences or what people have witnessed, for example, somebody else with dementia, and reacts to that. So that's what family can bring in. And it's also still advanced care planning if there is no family, but the person with dementia is capable of at least one conversation with a healthcare professional. And what happens if there's no family? That's what our expert panel asked. Well, if there's no family and nobody knows about the wishes of the person with dementia, it's not advanced care planning, but still you need to do some form of care planning. So it could be best interest planning, or you call it proxy planning, or goals of care discussions with a healthcare professional, but you should still do some form of care planning. And then finally, I have explained a lot about the framework actually of advanced care planning, and we are still working on what's the best approach, what can you say, how do you start a conversation. And we are actually in a project comparing two approaches, a more medical approach, which has the benefit that the doctor knows what to do in the case of a crisis, and a more psychosocial approach, which is much easier for the person with dementia and the caregiver, and compare the acceptability and effects of those approaches. But there's still a lot of more work to do and research in this area. Thank you.
Thank you, Jenny. Thank you very much. Yeah, please, the four of you stay there, and there's room for discussion or questions now. So, who wants to be the first? Kevin, you get the mic. Just a moment. Yeah, I see there's also a question coming from one of the participants from a distance, but first you.
Yes, so thank you very much. It was really an amazing panel. I had a question for Adrian that then extends also to the others. So you talked about advanced directives sort of continuing to sort of go under the surface, under the tunnel, and then when they re-emerge, they need to be at the top of the hierarchy. In a way, I was wondering, well, first, maybe there is also a question of demolishing the tunnel and bring the advanced directive into the surface first, and also if there can be tensions between what you were saying about putting advanced decisions at the top of the hierarchy and what the others were saying about healthcare planning and sort of a dynamic approach to advanced decisions. Thank you.
Yeah, please.
Okay, first of all, our project's at a very early stage. And when I'm speaking more lengthily about it, I say I'm speaking about the project, not for the project, because we're just over 30 people and we have a lot of views. Emerging principle is, first of all, that we call it an advanced choice, not an advanced directive. For a simple reason, I can't tell a doctor what to do in most systems. The doctor is prepared by his professional standards to offer me something, and the choice is accept it or not, or maybe some alternatives. And maybe discuss a bit and there's more comes up, but it's a choice. And in other purposes, we thought we call it an advanced choice. We wanted this to have maximum availability. Okay? So, not get greatly hung up on this old capacity, lack of capacity. If somebody can tell you what they want and you can write it down, and we're talking about not just a written document, but possibly a video recording or whatever. So maximum availability, but what do you do when it comes out of the tunnel? And you never disregard it. You never say, that was incapably offered. What you may do is to give it greater or lesser weight. And we're working towards having criteria for disapplying it. In other words, it applies unless. And a factor has got to be the degree of formality at the outset. A factor has got to be what I said in my little talk. Have people consulted at that stage? Who have they discussed it with? And record that in the document. A practical recommendation will probably be that if it is a fairly formal document and it's lodged with a notary or whoever, recommend to the grantor that every 6 months or every year, have a look at it and write a letter. This is still what I want, or otherwise, and ask the notary to keep it with the document. So, but you can't have a perfect answer. You've just got to try and build these various things together. I don't know whether I've answered all of your question, Kevin, or not.
Okay. Yeah, okay. Thank you. Eefje, you want to comment as well, because I saw you knocking, etc. The phone is yours. If you no?
No, not particularly.
Okay.
Unless you have a question for me.
I mean, it was whether you see some potential tensions with the hierarchy
Yeah, if you look at the Dutch law, there's a clear well, I cannot pronounce the word, hierarchy. But then it's first the person, of course, and then the advance directive, and then the legal representative. But this is not in every jurisdiction, so I was trying to capture that in my presentation, but I actually cut it out. But I feel the tension because I think all three are relevant and all three need to be considered. And the way you consider them, and I try to capture that in the shades of gray, is somewhat more black, somewhat more white, but you always, even the legal representative, should look at the wish of the person and not his own wish. But all these arguments
of course.
are important.
Okay, thank you. There may be another question. Yes. Is the phone near or coming to you? Yeah. Are you willing to introduce yourself as well? Discipline, country?
Hello, I'm an anthropologist, so it's a bit as well that direction question. I was listening to this and thinking how this is going to work with our migrant population, which is getting older. In that sense, where, this may be a question more for Adrian, where in that interdisciplinary decision-making team is, and by whom is the culture of the person represented? Because imagine, as a migrant, you move to the country, you adapt somewhat in the 20 years you work here, and then you make everything arranged, and then you forget that integration. You don't speak the language anymore. Your children probably don't know your basic culture. Who in this, and you might want to make different choices based on your natural culture and not adapted culture, how that would work in this situation?
Can you comment on it?
On migrants, yeah, who wants the floor?
I think the concept, if someone is the same. You ask the person, and you ask the people around, and you look at what is written down, but we haven't studied it. And I think it's the culture that this is kind of based on the Western culture, and the culture aspect can be a thing. Because there are other values, and the family, for example, is really important in these cultures. But I'm not a specialist in this field, so I feel uncomfortable answering. So maybe someone here?
I don't think there has been much research on that yet, so there is still more research to do. What I do know, what we explored, is what is a good death in 8 countries. Pooling qualitative data of persons with dementia and family caregivers. And there are some differences, like in Asian cultures, that family is more important. But it wasn't that different, actually. Because the situation is somehow the same, that family comes in, and family gets more important also at the end of life. So I think that there are some differences, but the main psychosocial issues and what's important to people, they aren't that different, that we are all humans.
I think there are differences, and our project is a model laws for Europe, and almost our starting point here is every culture in the world is going to be represented somewhere in Europe, and some of the larger countries probably have most of them somewhere, so we're very aware of that, and we're very much looking at that dimension. And European Law Institute, it's quite well structured. We have a thing called a Members' Consultative Committee, and any member of the Institute can join the Consultative Committee for our project. And for example, we've had somebody from Japan has actually become a member of a European institute in order to come onto our Consultative Committee. And I think there are differences.
Perhaps I can come in there. I think there are many individual differences, and that's why we do advanced care planning, and that's why we develop models with different care goals, so people can choose from that. But I'm not sure that the model itself need to be that different.
No, but there are concepts which I think are rather Western-oriented. I've written a piece, is autonomy a purely Western concept? Because if we talk to our colleagues in East Asia, for example, and affected by Confucian approach, And don't tell me that the population of mainland China isn't in that category. They are, I've been there. Then, what's important? Well, it's the good of the family, it's the good of society. And you almost don't shout about your own wishes and preferences. So there are issues there. We're just at the beginning, but I think I would tend to agree with your angle that it's not just individual by individual, but there are different dynamics that we have to look at.
Okay, one other question, the next one, Elke, yeah.
If someone wants
Yes.
to react, I think maybe.
Sorry?
I don't know who. We're the first. Okay,
I think
please go.
in the process of doing ACP, it's also important, just as Jenny told, to include also the family perspective in dementia. So, yeah, I don't believe the ACP in practice is that individual. So maybe that might also include the cultural aspects.
Well, that's a nice bridge for my remark, because in care ethics, often an example is expressed of the resident who had been his whole life a vegetarian, comes to the nursing home, and by accident gets a meatball,
yeah,
and then he says, "Why didn't I have this before?" And from now on, I want to eat meat. And in this case, it's brought by the philosopher Hilde Lindemann. She discusses this because there's a lot of moral dilemmas in it, because the family really wants to hold on to his old identity of being an activist on not eating meat. Well, now the resident has changed his mind or his taste and wants to eat meat. So I was wondering what your ideas are about when advanced choices expire in a way, or and what the role is of the family in holding on to the identity of the person.
The question is to?
Well, I think you raise an important question, and there are a lot of ethical dilemmas in the nursing home, and I think the best way of handling these dilemmas is to consider all their perspectives, and then consider the perspective of the person and his long-held beliefs as a vegetarian, but also the current perspective of the person here and his pros and cons, but also the perspective of the family. And you do that, you're an ethic, you do that in an ethical dilemma method, for example. And I think this is a good case just to, and then you weigh, and I think there's no good answer. The answer is what you think best, weighing all the options. And then...
There may be an answer to the big question that we started with, because I have to sum up a bit at the moment, I think. Yeah.
Yes, we started case because an element we're looking at is how do you, first of all, you have criteria for not applying the past thing, but who decides? And we're looking at, should the grantor be able to specify a mechanism? And we're a bit influenced, back to East Asia again, actually, the idea of almost like a family committee. A fairly broad number of people. And I would just specify, boom, 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 boom.
Yeah.
And if you really think you need to disregard something I've said, and perhaps go along with what I seem to be saying at some future stage, get them all together and let them be the ultimate arbiter. Someone's got to decide somewhere, and it's either a mechanism like that, or, I'm afraid this is the lawyer speaking, ultimately it's going to be a judge somewhere.
At the end, but almost at the end. Yeah, we really emphasize, and I think this is successful for this session, that there are instruments, but there's no reality black and white. There should be a process, there should be communication and advanced care planning in talking with each other. And then you see that there's potential in the instruments. And then for me, this is successful. We're not ending the discussion yet, but for time reasons, we quit here. And you are still here for talks and coffee and explanation, right? But I want to thank you all for having a splendid presentation. Thank you for being here, and thanks the others for being connected with us. Have a good day.